Hello, everyone, and welcome to our webinar today, California Privacy, CCPA and Beyond. Before we begin, we'd like to give you a few housekeeping items. If you have any questions during the webcast, you could submit them through the Q&A widget that's at the bottom of your screen. We'll try to answer questions as we go through the webcast, but if a fuller answer is needed or we're getting short on time, we'll answer them later by email. A copy of the slide deck for today's presentation, as well as other materials, are available in the resource widget. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. The webinar today is CLE accredited in California for 1.0 hours of general credit, in Illinois for 1.0 hours of general credit, in Missouri for 1.2 hours general credit, in New York for 1.0 general credit, which is pending, and in Texas for 1.0 general credits, also pending. We award CLE based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you'll notice that we are no longer using automated pop-up attendance checks. As required, we will display secret words in 2 multiple choice polls during the webinar. You'll be required to select today's secret word, which we'll give verbally, from a multiple choice list that will appear on your screen. Please respond to these 2 polling questions to demonstrate your continued engagement and to earn the full CLE credit. Your CLE certificate will be emailed to you later this afternoon once we've verified your attendance. The widget at the bottom of the screen saying certificate will only show whether or not you have earned the certificate. We value your opinions and appreciate your participation in today's webinar. With that, I'd like to again thank you for attending. We have an excellent webinar today with some very good panelists. I'm Jim Shreve. I'm the chair of the cybersecurity practice at Thomson Coburn. I'm based in the Chicago and DC offices, and I advise clients on a lot of different issues relating to data governance of all types, whether it's privacy, collection, sharing, use of information, or security of information, or what to do with if there's some security incident relating to information or systems. I'll pass it to my colleague, Luke.
Well, hi, everybody, and thank you very much for attending. We very much appreciate it. My name is Luke Sosnicki. I am a partner in Thomson Coburn's Los Angeles office. I'm a litigator. I spent most of my career defending largely financial institutions in all sorts of consumer lawsuits, individual and class, across the country. I also have a very active privacy-oriented practice that's aimed mostly at advising not just financial institutions, but all sorts of entities on the regulatory and litigation risks based on various privacy-related liabilities and privacy regimes. So thank you again. Libby?
Good afternoon. My name is Libby Casali, and I am an associate in the Business Litigation Practice Group at Thomson Coburn. I am located in the St. Louis office, and I also work in the cybersecurity group.
So thanks, Luke and Libby. So what are we going to talk about today? No state has been more important in the development of privacy requirements in the United States than California. It's been a leader in this space for an awful long time. It goes all the way back to the California Constitution. And so Luke is going to talk about some of these important early requirements in California privacy. Then we're going to look at some sort of the next wave of California privacy laws that came about in the 2000s with a few important things there. And then kind of this third wave that we've seen just in the last few years, consumer protection laws that are focused on privacy information. And what are some of these new obligations for businesses, and what are some of the rights that consumers have on this? And then also, what kind of liability could a company face under these various California privacy laws, as well as then what's next? So where might California go next on some of these privacy issues, and how might other states use what we hear, or what California has done, what might be done in other states along those lines, or maybe building on to what California has done. So with that, pass it on to Luke Znicki to talk about some early California privacy requirements.
Thank you, Jim. So maybe a good place to start is with the passage of the recent passage of the CCPA and the ongoing, or the soon-to-be passage of the CPRA. I think it's important to note that while both of these statutes include very new concepts, both also build on a pretty lengthy and pretty long history of the development of privacy rights in California. And as you'll see, I mean, a lot of the concepts, including a lot of the obligations with respect to privacy, just build on prior developments of prior statutes. So one of the key building blocks was that in California, and a lot of people kind of forgot about this, but in California, privacy is actually a state constitutional right. So pursuant to a ballot measure from 1972, privacy was added, the right to privacy was added as an inalienable right to California's state constitution. And the measure and the amendment was aimed not towards private entities' use and collection of information. It was aimed mostly to guard against government surveillance and government collection of records. And there's been a fairly significant body of law that's developed since then, in some ways similar to the federal law that arises from the federal Constitution. But over the years, it's been applied to, for example, challenging police conduct and using undercover agents to collect dossiers on students. That was one particular case. In civil discovery to protect the confidentiality of financial and bank records, and in a mirror to some federal cases as well, to challenge zoning laws that, for example, required homes to be occupied by families. But as pertains to our discussion today, the building blocks of a right to privacy are importantly codified in the Constitution itself. Next statute is the Song-Beverly Credit Card Act that was implemented in 1971, and that was a law specifically prohibiting the entities that took credit card payments, businesses that take credit card payments, from collecting certain personal information from consumers as a condition of accepting credit card payments, or suggesting to consumers that the collection of personal information would be required to use credit cards. Again, an early nod to consumer rights with respect to the privacy of their personally identifiable information. The statute, the current version, the current implementation of that statute is subject to numerous exemptions, including some that apply in some ways to online merchants, cash advances, special purpose orders, including shipping. But the key concept of prohibiting entities or prohibiting businesses that take credit cards from collecting certain personal information remains in place even today. The Information Practices Act, passed in 1977, passed mostly to implement the state constitutional ballot measure, including a right to privacy, intended to codify that. It applies to state government agencies, and it specifically limits how the agencies collect and retain personal information. One of the key provisions is that agencies under the law are required to collect and use information only as necessary to accomplish that agency's specific purpose. The state agencies must also provide access to state residents relating to collected information. and provide certain notices on forms by which the agencies collect the information to the consumers, so that, or to the California residents, so that people have some idea of what information is being collected, which again is a early nod to the concept of that's certainly front and center with the CCPA and CPRA of informing residents and consumers regarding what type of information is being collected and how it may be accessed. Next statute, the IIPPA, the Insurance Information and Privacy Protection Act, took effect in 1981, specific to insurers and insurers' collection of personal information. And this statute, which again is quite a while ago now, requires, and still in effect today, requires privacy notices in insurance applications or issued in connection with insurance applications that specifically inform the applicants regarding what information the insurance company is collecting to process the application to issue insurance. And again, quite an early nod to the concept of informing the consumers in writing regarding their what information is being collected and how it's being used. And with that, I'll turn it over to Jim to fast forward at least 20 years into some laws that, some subsequent laws that build on some of these foundations.
Well, thanks, Luke. And I would like to point out, it's really, truly amazing how many privacy-related laws there are in California. If you go onto the state AG's website, or just even Google, California Attorney General privacy laws, they have a place on the site that lists all of the various California privacy laws. And if you print off that list where they have the law and the blurb on it, I believe it's 19 pages long. So there's just an incredible number of them. We're talking about some of the more important ones, but keep in mind there are a lot more. And so with that, I'd like to move on into the Financial Information Privacy Act, which is a law I don't think you can really understand unless you understand the federal Gramm-Leach-Bliley Act, which was enacted in 1999. It applies to financial institutions, which has a very, very broad definition, entities significantly engaged in activities financial in nature, but those activities are defined very broadly. So you can get a lot of entities that wouldn't necessarily think of themselves as financial institutions, but there are. And then GLBA puts requirements on financial institutions sharing of non-affiliate or sharing of non-public personal information with non-affiliated entities, including opt-outs for certain sharing. It has provisions on joint marketing where it does not require an opt-out for that, and limits on the use of non-public personal information that was shared under an exception to the opt-out requirements, as well as requirements on safeguarding of NPI. Now, GLBA explicitly permits states to go further in these areas. And so the Financial Information Privacy Act is what California did under GLBA. It was enacted in 2003. It covers generally the same ground as GLBA, but for the most part requires an opt-in for sharing that under GLBA requires an opt-out, and it requires an opt-out be offered for joint marketing, which is not required under GLBA. Now, it also contains requirements for financial institutions sharing of NPI with affiliates. And I would note that this area of sharing is regulated by the Fair Credit Reporting Act, Federal Fair Credit Reporting Act, which does not permit states to go further. And so in this case, the Ninth Circuit found that portions of the Financial Information Privacy Act that regulate affiliate sharing that's within FCRA are preempted. And so effectively, really all of the affiliate sharing provisions in the FIPA are preempted. I would note, though, that language is still on the books. So there are other states that have done this as well. So Vermont and North Dakota have also followed California in some respects at requiring opt-ins for information that under GLBA requires only an opt-out. But I would note that California, because of its size, because of its importance in the economy, impacts national operations in a much greater way. I would note that generally this is an area where sometimes California will pass a law and it will act as the national standard. And it'll effectively then be applied to people who are subject to the law or not. But this is one where entities that are subject to the Financial Information Privacy Act do generally treat California residents differently. And so if you look at the privacy notices, they'll have specific provisions on California. Next one I'm going to talk about is Shine the Light, which is a lot of that you may hear about sometimes, but it had less of an effect, at least less of a direct effect. It was enacted in 2004, and it relates to personal information of a customer that is used in direct marketing. So customer is defined to include a California resident obtaining product or service for personal, family, or household purposes, and includes the definition of business includes both for-profit and not-for-profit businesses. So on a request from a customer, business must disclose, one, the types of personal information that is shared by the business with third parties for the third party's own direct marketing purposes during the prior year, as well as the names of those third parties with which the business shares the personal information for those purposes. It contains other requirements relating to identifying and responding to customer requests, and I would note that it exempts entities that are subject to and in compliance with the Financial Information Privacy Act. And so what I think is interesting about Shine the Light is that it's a very early time when you can see some of the foundations that later went into CCPA, you can see here. Some of those same concepts that were that are maybe in more simple in form in 2000s now, almost 20 years later, are being incorporated into a much broader, more stringent law. With that, I'll pass it back to Luke for CalAPA.
Thank you, Jim. Okay, so CalAPA passed in 2004, and the statute specifically requires commercial websites to post a privacy policy. And the privacy policy, among other things, lists the categories of personal information that the website collects, categories of third parties with whom information is shared, must inform consumers how material changes to the policy will be communicated, and must include an effective date. And building on what Jim said, you can start to see as we kind of move through these, the various building blocks of the CCPA and of the CPRA. Certainly the concept of listing categories of collected information and categories of shared information was directly just building upon prior statutes. And finally, the Office of Privacy Protection. So this is the first state agency dedicated to protecting privacy rights. It opened in 2001. Less of an enforcement role. It was focused on education and advocacy. Stated mission was to enforce state and federal privacy laws, empower Californians with information about rights and strategies for protecting their privacy, encouraging businesses to follow privacy best practices, and advising the California Attorney General on privacy matters. Its director the entire time of its existence was Joanne McNabb. The office is ultimately closed because of budgetary constraints in 2012, but its responsibilities were transferred to the AG's office, and Joanne McNabb also at that time took a role with the AG's office. But what's notable is not just that it was the first state agency so specifically tasked, but also really the scope of the responsibilities that it was asked to handle. And again, kind of on this theme of building blocks, certainly a significant impact on future legislation. So I think that takes us to our first secret word of the day, and first poll question. And today's first secret word is receipt. Again, it's receipt. And I'll give everybody some time to choose the correct answer, please. And just to make sure, I'll repeat it one last time and then I'll move on to the next slide. The secret word is receipt. Okay, so moving on. So how did we get from everything that we've just discussed, albeit quite quickly and in passing, but how did we get to where we've been to where we are now? And I think as a lot of folks on this call will probably know, where we are now is the CCPA, and very shortly the CPRA. So the CCPA actually began as a ballot initiative back in 2018. It was spearheaded by a gentleman named Alistair McTaggart, who's a Bay Area developer. He's not an attorney. He's nor was he an elected representative or elected official. He's a private developer who, the story goes, based on a conversation with one of his colleagues one day over their mutual curiosity about what personal information private entities are collecting about them, decided to put together a ballot initiative that would apply more generally to businesses doing business in California and require them to disclose certain information to consumers and allow consumers to some control over the information that businesses collect as well. So the ballot initiative, again, started in 2018. The California's ballot initiative process requires a certain number of signatures to be collected before an initiative is placed on that year's ballot. And when it became clear to the California legislature at some point that this initiative was very likely to pass, the legislature struck a deal with Mr. McTaggart to pass the statute substantially in similar form to the ballot initiative with some changes, but actually pass it through the legislative process and get it on the books that way, which would leave the legislature some control over the final product. But that said, it was still passed relatively quickly, including given how it was brought up, and required some very quick amendments even after it was passed to cure some issues that had been maybe not completely buttoned up and remained unresolved. So the statute itself took effect in January of 2020. Because of how it was passed, the implementing regulations were actually passed, or were finalized thereafter. The implementing regulations weren't finalized until about 8 months later in August, which actually created an interesting situation because the effective date of the Attorney General's enforcement of the CCPA was July 1st, 2020. So the effective date of enforcement was actually before the regulations were finalized sometime later. And the regulations, just like the statute, have gone through a series of updates and amendments, and which is also interesting in itself because before the regulations have even kind of been finalized, or if they have been finalized before they've been given an opportunity to settle in, a new statute is already on the horizon, and that's the CPRA, which is scheduled to take effect in 2023. And with that, I'll pass it to Libby tell us about the CPRA.
Thanks, Luke. The CPRA, or the Californians for Consumer Privacy, CPRA stands for the California Privacy Rights Act, and that was sponsored by the Californians for Consumer Privacy in 2020, and that was Proposition 24. The Californians for Consumer Privacy is also led by Alistair McTaggart that Luke was just discussing with respect to CCPA. And the CPRA passed in the general election in November 2020 with over 9.3 million votes. And the CPRA amends and expands the CCPA. And it's important to note that the CPRA has the same acronym as the California Public Records Act. They are different, but that can sometimes cause some confusion. But as Luke mentioned, the CPRA, most provisions will not be enforceable until July 1st, 2023, but some changes did take effect immediately. And they only apply to personal information collected after January 1st, 2022. However, the CPRA also extended the limited CCPA exemption for business-to-business data until January 1st, 2023. So with the passage of CPRA, it becomes a baseline for California consumer privacy because it requires that any subsequent amendments be consistent with and further the purpose and intent of the Act. So if the California legislature passed a CPRA amendment that might be privacy restrictive, privacy advocates could attempt to try to repeal that amendment. But CPRA could also be modified as well through a subsequent ballot measure. So some changes from CCPA to CPRA include modification of the definition of a covered business. The CPRA increases the threshold number of consumers or households from 50,000 to 100,000. It also extends applicability to businesses that generate revenue from sharing personal information, not just from selling that information. And it extends the definition of to joint ventures or partnerships made up of businesses that at least have a 40% interest. The CPRA also adds the category of sensitive personal information and provides for new rights designed to limit businesses' use of sensitive personal information. So sensitive personal information includes things such as government identifiers, like a social security number or driver's license, financial account and login information, precise geolocation, race, ethnicity, religious or philosophical beliefs, union membership, and so on. And the new definition of sharing of personal information from CPRA requires that businesses that share personal information offer an opt-out. CPRA also made alterations to the definition of service provider, as well as provided an update to the private right of action for data breaches. So the CPRA expands the existing private right of action and clarifies that a company may be liable for unauthorized access to or disclosure of an email address and password or security question that would permit access to an account, along with access to a consumer's non-encrypted and non-redacted personal information, if that access is attributed to a business's failure to maintain reasonable safeguards. Another change with the CPRA is the creation of the California Privacy Protection Agency, and that a 5-member inaugural board was announced on March 17, 2021. And that California Privacy Protection Agency is granted investigative, enforcement, and rulemaking powers. Further changes with CPRA include the removal of the 30-day cure period before being subject to administrative enforcement, requirement that businesses receiving verified consumer requests to delete personal information must not only direct service providers to delete that information, but also all third parties to whom the business has sold or shared such personal information, unless that notice would provide impossible or would it also involve disproportionate effort. Further, the CPRA creates the right to correct inaccurate personal information, and it triples existing CCPA penalties for violations regarding the processing of personal information of minors under the age of 16. And finally, the CPRA also affirmatively regulates dark patterns, stating that consent obtained through dark patterns does not constitute consent. And the CPRA defines a dark pattern as a user interface designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision-making, or choice. Now we're going to turn to new privacy rights for California residents. So CCPA gives California consumers control over the personal information that businesses collect about them. As set out in the slide, the CCPA provides right to know about the personal information a business collects about them and how it is used and shared, right to delete personal information collected about them, right to opt out of sale of their personal data, right to non-discrimination or equal treatment for exercising CCPA rights, right to access personal information, and also requires that businesses implement and maintain reasonable security procedures. The CPRA expands the right to know, and that impacts personal information collected during the period on or after January 1st, 2022. The CPRA also creates some new rights. So that includes the right to correction of personal information if that information is inaccurate, the right to opt out of automated decision-making technology, the right to access information about automated decision-making, the right to restrict sensitive personal information, so that is with respect to the potential use and disclosure of sensitive personal information for certain secondary purposes, and audit obligations. And then it also modifies some of the rights that are set out in CCPA. So that includes a modified right to delete, an expanded right to know, an expanded right to opt out, strengthened opt-in rights for minors, as well as the expanded right to data portability. And now we'll turn to new privacy obligations for businesses. So with respect to notices, the CCPA requires that businesses give consumers certain information in a notice at or before collection. That notice at collection must list the categories of personal information businesses collect about consumers and the purposes for which they use the categories of information. If the business sells consumers' personal information, then the notice at collection must include a do not sell link. The notice must also contain a link to the business's privacy policy, where consumers can get a fuller description of the business's privacy practices and of their privacy rights. And the privacy policy must also include information on a consumer's privacy rights and how to exercise them. And the law and regulations further set out the requirements for privacy policies. Further, businesses need to respond to verifiable consumer requests. The business needs to include at least 2 methods for consumers to submit a request, including a toll-free number, email address, website form, or hard copy form. Businesses must respond within 45 calendar days. However, they can extend that deadline by another 45 days if they notify the consumer. Businesses must verify that the person making a request to delete is the consumer about whom the business has that personal information. Businesses can also ask for additional information for verification purposes. And if the business asks for personal information to verify identity, it can only use that information for that verification purpose. There are a few limited exceptions that might allow a business to deny a request to delete. A business also must maintain reasonable security procedures and practices. And the private right of action created by the CCPA may be brought only for data breaches arising from a business's failure to maintain reasonable security measures and not any other failures to comply with the CCPA. The private right of action for consumers whose non-encrypted or non-redacted personal information is subject to an unauthorized access and exfiltration, theft, or disclosure as a result of the business's violation of the duty to implement and maintain reasonable security procedures and practices would allow for that private right of action. Consumers can recover injunctive or declaratory relief and damages. And in an action for statutory damages, consumers have to give a business 30 days written notice of the alleged violation. And if the alleged violation is cured, no action for individual statutory damages can be brought. And under the CPRA, any consumer whose non-encrypted and non-redacted personal information or whose email address in combination with a password or security question and answer is subject can bring that civil action. And consumers can again recover injunctive or declaratory relief and damages in an amount not less than $100 and not greater than $750. In an action for statutory damages, consumers are required to give that business that 30 days written notice as well. And then finally, businesses must keep records of compliance, and Regulation 999.317 requires and sets out requirements relating to that compliance. Now I will turn it back over to Jim.
Thanks so much, Libby. So CCPA as a statute was enacted very quickly because of the need to get it enacted before the deadline to remove the ballot initiative. It came together very quickly, and so as a result, many of the parts of it don't honestly come together terribly well. There are several areas of ambiguity And I think the legislature recognized that regulations would be necessary to address several issues under the law. Well, with the Office of Privacy Protection no longer around, the legislature gave regulatory and enforcement authority both to the California AG's office, which is an unusual role. Enforcement certainly is normal for an AG's office, but being the regulator, being the interpreter of the statute is somewhat unusual for them. But the AG's office solicited public comment, input, and released several items. They issued the proposed regulations in October of 2019. They issued the statement of reasons, which is kind of a legislative regulatory history of the law in June of 2020. They issued the final regulations in August of 2020, and then since that time, they've had periodic amendments to the regulations. CPRA was enacted in November of 2020, and that, it's been noted, that law established the new California Privacy Protection Agency. Board members to the new agency were named in March of this year. It held its first public meeting just recently on June 14th of 2021. The CCPA was given rulemaking authority over both CCPA and CPRA. It will kind of assume that regulatory role from the AG's office. It's not clear exactly when that transition is going to happen, at least as far as CCPA goes. The AG's office is still issuing CCPA interpretations at this point. Under CPRA, the new agency must adopt final regulations under that law by July 1st of 2022. I would note that the AG's office continues, as I noted, continues to be active on CCPA, and they recently amended an FAQ on their website about CCPA to address something called the Global Privacy Control, which is a web browser extension that sends a signal that the consumer wishes to opt out from sale of their personal information. And this involves the CCPA requirements that a consumer be able to direct a business not to sell personal information relating to that consumer. A business that does sell personal information must include a clear and conspicuous link on its website permitting consumers to exercise their opt-out right. The new edition in the FAQ states that a business must honor the global privacy control as a valid method for a consumer to opt out from sales of personal information. Prior regulations had noted more generally that universal opt-out mechanisms should be honored, but this makes it more concrete that you have to honor these kind of controls. I think this reflects a strong desire by the AG's office to make exercising privacy rights easier for the consumer, and I think we can certainly expect to see much more of this as we move forward. I would also note that the AG last week released something related to something they call the Consumer Privacy Interactive Tool, sometimes also just being called the Consumer Privacy Tool. The new tool is a means by which consumers can more easily notify a business if the consumer believes the business is not complying with do not sell notice requirements. The AG's office has said that this submitting something under this new consumer privacy tool may start the 30-day cure period for a business before the AG's office can initiate an action against the business for non-compliance. So with that, let's talk a bit more about liability. Luke.
Thank you, Jim. Okay, so where are we now? So we started back at least as far back as the 70s, went through a progression of building kind of the building blocks of the privacy laws up through the current status quo, which is CCPA, and very soon to be CPRA. So what's the big difference? What exactly has changed in the largest respect? And as Libby kind of went through, one of the biggest changes was businesses' obligations with respect to the data they collect. Another significant change was consumers' rights with respect to the businesses that, or the information that businesses collect about them. And another fairly significant change is the new privacy-related liability for businesses that California's current statute imposes. So the CCPA specifically codifies penalties for noncompliance. It codifies up to $2,500 per violation or $7,500 for an intentional violation. And as I mentioned before, the Attorney General did start enforcing the CCPA in July of last year. So far, there have been no publicly disclosed actions filed, but just recently, and to show you we're absolutely on the cutting edge, on July 19th, just a few days ago, the Attorney General released a press release titled A First-Year Enforcement Update on the CCPA. And it was a relatively brief release, but it was in the form of we being the Attorney General's office, are actively pursuing enforcement of the statute. It provided some examples of various potential violations that the Attorney General had pursued, including failure to inform consumers of what information was being collected, failure to respond timely to access requests, and failure to implement, as is required, do not sell, opt-out provisions for consumers to exercise. According to the AG's office, of the letters that the AG's office of the noncompliance notices that the AG's office began sending in July of last year, 75% have been complied with, and the remaining 25% are subject to active investigation. So again, much of their information isn't public, but we at least have a glimpse into the fact that the AG is pursuing enforcement. The other half of potential liability under the CCPA is a specific provision that, as Libby also discussed a little bit earlier, that grants private right of action for certain data breaches. The private right of action is limited to only certain types of information. And again, the statute itself is privately actionable only for data breaches, and not just for data breaches, but for data breaches based on a failure to implement reasonable security measures. The statute also includes codified damages for a violation of the privately actionable provision, and that's $100 to $750 per incident, per consumer, or whatever actual damages a consumer can prove. Again, that's in the statute, which is certainly unique. Data breach and privacy litigation is not new. Entities had been sued based on their loss of personal information before, but the codified penalty for the private right of action is something new with the CCPA. So what's going on with CCPA since the statute took effect in January of 2020? Quite a bit, actually. So at least 73 class action lawsuits were filed in federal court in 2020, in just the first year that the statute was in effect. Now, many of those lawsuits were filed against the same entity. Some were multiple suits were filed against the same entity. Nonetheless, quite a lot of litigation activity right off the bat. Many of these filings follow publicized data breaches. So all states at this point including California, have data breach notification laws. If an entity, and they vary state by state, but the general principle is if an entity is breached, it must and loses personal information, it must report that to a state agency, typically the Attorney General's office, and that information is made publicly available to Californians, so to anyone who accesses the information online, which fact has not escaped, unsurprisingly, plaintiffs' lawyers. So a lot of these lawsuits do follow very widely publicized data breaches, and sometimes very shortly after these data breaches, alleging on behalf of affected consumers private claims based on the breach itself. So what have we learned so far based on the first year, and I guess at this point the year and a half, of CCPA litigation? So there actually aren't that many opinions interpreting the CCPAs, or at least specifically interpreting the CCPA's provision yet. Most of these cases are federal cases, and as the litigators on the call will know, federal cases certainly take some time to wind their way through the courts. And a lot of court activity was also, at least initially, slowed by the COVID pandemic. So again, there isn't a huge body of case law interpreting the CCPA's private right of action. That said, there are certainly some markers, certainly some things that are interesting to both plaintiffs and defense lawyers. One of the things that has come out is that a plaintiff must sufficiently plead that the defendant's security was deficient. It's not enough to plead that there was a breach. Courts have also, at least a court has also required that the complaint itself explain why security was deficient, or why the plaintiff believes the security was deficient and not reasonable as a pleading requirement of bringing the claim. So it's not enough to simply state on X and Y date my information was breached, therefore I have a CCPA claim. Another, I think, very important ruling is that standing might still be a defense. One of the very popular and widely used and very successfully used defenses in data breach cases before the CCPA was the concept of Article 3 standing, which basically, in very short summary, is in order for a plaintiff to plead a claim in federal court, he or she must show actual injury. So you were actually injured by the conduct for which you're seeking redress in court. And I mean, that's a bit of an oversimplification, but that's the gist. And in many of data breach cases predating the CCPA, the defense counsel or the defendant successfully argued that the plaintiffs couldn't show actual injury or actual harm to sustain their claims. So yes, the data was lost. Yes, the data was compromised. But beyond the fact of the loss of the data itself, you haven't been harmed. Therefore, you can't state, you can't maintain an action in federal court. And one of the big concerns with the CCPA was, now that the CCPA codifies a private right of action for data breach and imposes statutory damages that you can plead as an alternative to actual injury, how is that going to affect this very widely used and successfully used argument that was that defendants used to get these cases dismissed? And the answer, at least according to one court in the Rahman Ramiriak case, is no. Standing is going to continue to be a defense if you're pleading these cases in federal court. Another important opinion determined that a pleading a complaint under the CCPA doesn't need to plead that the information was stolen. Disclosure is enough. And finally, in a really, I thought, really one of the interesting opinions in the case, and I thought really kind of interesting use of the CCPA in civil litigation, was this notion that the CCPA can be used in civil discovery as the basis for an objection to producing personally identifiable, consumers' personally identifiable information that might be in one of the litigants' possession. So the question was, is a CCPA covered business that is required in civil discovery to produce personal information in its possession prohibited from doing so, or at least restricted from doing so under the CCPA based on the consumer's understanding of how that information would be disclosed and used. And the court kind of dealt with that, I thought, I don't want to say it, well, the court's ultimate conclusion was that no, the CCPA is not, it's not a new basis to withhold or to object to the production of information in civil litigation. It's certainly a consideration, but it's not a bar for defense or for entities to produce information that's otherwise required in a case. So again, we don't have as much guidance perhaps as we would like. There's still a lot of very important questions relating to the CCPA's private right of action that haven't yet been resolved, including, really interestingly, things like, can you bring a UCL claim based on a CCPA violation as a private claim? That's still somewhat in the air. And again, just the several other points that it's just going to simply take more litigation to resolve, and obviously a complicating factor being that the CCPA itself is going to be transmorphed into the CPRA pretty quickly here. So long story short, very fluid situation, but certainly some interesting rulings coming out. And with that, I'm going to turn it over to Jim, who I think has our second top secret question of the day.
Thank you, Luke. The second secret word today is lunch. So please select lunch from the list on the screen right now. I'll give you a few seconds to go ahead and do that. All right, thank you. So what might be next? So where might things be going from here in California? First thing I'd like to touch on just briefly is whether California could become an adequate jurisdiction under the European Union's GDPR. Under GDPR, several countries are listed as providing legal protections that are comparable to those as under GDPR itself. The U.S. as a whole does not qualify for that, but there has been discussion in the last few years about if by enacting more stringent privacy requirements, California could be named as an adequate jurisdiction, even if the rest of the U.S. is not. And members of the European Commission have said that a sub-federal level jurisdiction like California could be designated as adequate, or as far as the EU is concerned, California would need to apply for that. I think what is less clear at this point is if this is permissible under U.S. or California law, and then we'd have to look into substantively whether or not the addition of CCPA and CPRA address many of the past complaints made by the EU about the lack of U.S. privacy protections. These laws do give significantly greater privacy rights to individuals. Many of those are fairly close to what you see under GDPR. And maybe more importantly, the laws give enforcement authority to an agency more or less across the board, which has been something that's been complained about in the U.S. at the federal level, that enforcement authority is so fractured. So with that, Libby, tell us more about what we've seen in other states.
Thanks, Jim. So just this year, Virginia and Colorado passed laws. The Colorado Privacy Act was signed on July 7th, 2021, and the Virginia Consumer Data Protection Act was signed on March 2nd, 2021. The Colorado Privacy Act takes effect on July 1st, 2023, and the Virginia Consumer Data Protection Act takes effect on January 1st, 2023. So between those, there's similarities but also differences. So in comparing the California Privacy Rights Act, Virginia Consumer Data Protection Act, and Colorado Privacy Act, so all passed within the last year or so, there's some differences, for example, among who's responsible for enforcement. So in California, under the CPRA, the California Attorney General and California Privacy Protection Agency are involved in enforcement, whereas in Virginia, the Attorney General is the exclusive enforcer of the Virginia Consumer Data Protection Act, and in Colorado, the Attorney General and District Attorneys would be responsible for enforcement. There's also differences in exemptions for types of entities. So in California, there's relatively few entity-wide exemptions, except for exemption for certain entities regulated by HIPAA or the Confidentiality of Medical Information Act. But California largely exempts nonprofits from most requirements of the law by defining businesses as for-profit entities. Virginia provides for entity-wide exemptions for financial institutions subject to the Gramm-Leach-Bliley Act, entities regulated by HIPAA, nonprofit organizations, and certain higher education institutions. And Colorado provides for entity-wide exemptions for financial institutions subject to Gramm-Leach-Bliley and affiliates and state institutions of higher education. But it lacks an entity-wide exemption for HIPAA-regulated entities. However, it does include broad exemptions for HIPAA-regulated data and certain other data maintained by covered entities, business associates, and other healthcare entities. But Colorado does apply to nonprofits that meet certain requirements, whereas Virginia and California exempt nonprofits. They differ also in exemptions for human resources and business-to-business data, the scope of opt-out requirements. So in California, it does allow for the opt-out of sale and sharing. Virginia allows for the opt-out of targeted advertising, sale of personal data, and profiling and furtherance of decisions that produce legal or similarly significant effects. And Colorado mirrors Virginia in that regard. They also differ in treatment of opt-out signals. So California allows a business to forego a do not sell or share my personal information link on their home pages if they allow consumers to signal their intent to exercise those rights via a technical opt-out signal that complies with specifications that are set forth in the regulations. And consumers may also authorize another person to exercise opt-out rights on their behalf, including through an opt-out preference signal, whereas Virginia does not have any provisions that address opt-out preference signals. Colorado does allow consumers to exercise their opt-out rights via authorized third parties, including via browser or device signals, but it also calls for the Attorney General to develop rules or a universal opt-out signal to allow consumers to opt out from targeted advertising and the sale of personal data, and controllers must offer that universal opt-out mechanism by July 1st, 2024. The states also differ in their treatment of sensitive data requirements. California allows for the right to limit use of sensitive personal information under the CPRA. Virginia requires that controllers obtain opt-in consumer consent to process sensitive data, and Colorado also requires that opt-in consumer consent to process sensitive data. They also differ in their treatment of contracting requirements, also their appeals for rights requests, cure periods, as well as the private right of action. So for California, the private right of action exists under the CCPA and CPRA. The Virginia law specifically states that there's no private right of action, as does Colorado. And other states this year have considered privacy acts but failed to pass them, such as Washington, Florida, Oklahoma, and Minnesota. Washington and Florida both failed in part over disagreements about whether it should include a private right of action. And other states that are considering laws currently include New York, North Carolina, and Ohio, and Pennsylvania. And now I'll turn it back to Jim.
Thanks, Libby. We're nearly finished here. I recognize we're getting to the top of the hour. Federal legislation. We continue to see bills introduced in Congress, but just as has been the case for the last 10 or 15 years, they aren't going anywhere. I think for all federal bills, there's an uphill climb. In addition to the same issue that Libby mentioned over and over again, the private right of action, there's difficult issues about preemption. Many, mostly on the Democratic side, are loath to preempt what they view as more stringent state law requirements with a new federal bill. But many often on the Republican side are saying, well, without preemption to create something that's more business friendly as a national standard, there's no point in having a federal bill. There's also the issue of committee jurisdiction. Many committees claim jurisdiction over issues that relate to privacy. There's well-documented a little bit of partisanship going on in Washington these days. And so because of all of this, I expect that states are going to continue to lead on privacy for some time. Luke, litigation.
Thank you, Jim. And it's 11 o'clock. I will do this in 15 seconds or less. The important thing, first of all, litigation is not going away. That's the takeaway. Litigation is going to continue. The CPRA actually expands the CCPA's private right of action to include other types of information, and there have been some CCPA settlements already that I think are going to encourage plaintiffs' lawyers to keep filing these suits. Really, the most interesting development, I think, in the next couple of years relating to litigation and liability for private claims is, as Libby and Jim both mentioned, what state level, what different states are going to do with respect to their laws. So far, the other two states that enacted similar legislation this year did not adopt a private right of action, did not pass a law that included private right of action in those states. It has been a contentious issue. In Florida, for example, that was a big point in contention. It's really going to be interesting to see whether a statute passed through the legislative process as opposed to being passed through a kind of a combination of a ballot initiative / legislative process, as was the CCPA, is going to come out the other end as privately actionable. If it is, and certainly entities, businesses that operate nationwide, if they're suddenly dealing with a patchwork of applicable privacy laws and a patchwork of applicable private rights of action, depending on which state you're operating in, I think that's going to be certainly challenging and definitely something to watch for. So, Jim.
All right. Well, thank you, Luke. Thanks to both our other presenters, and thank you for attending today. We appreciate it. We will continue to have privacy and cybersecurity topics for our webinars going forward later on this year. We thank you for participating in the webinar. Please complete and submit the survey that's in the widget at the bottom of your screen. And once again, thanks for coming today.